engineering is an industrial engineering student from Azhar University. I'm excited to be moderating today's lecture, and we explore the fascinating world of space law, especially delving into the legalese of the 1979 Moon Agreement. Before we begin our exploration today, please take a moment to watch the welcome remarks recordings from the Moon Village Association and International Moon Day. Okay, let me share the video.
I think we cannot hear the video.
Pardon? You can not hear the video?
Yes, I'm afraid the audio doesn't work, I think.
Okay, let me start it once. And now do you hear me?
Yes, I can hear you. Just only the video. Moon
Do you
Village.
hear me or not? I think you don't hear me.
We can hear you say that, but the video is very low.
Okay. I will. Now I play the video again.
So good morning, good afternoon, and good evening to everyone. I am Giuseppe Reibaldi, and I'm the president of the Moon Village Association. Let me first of all thank all the organizers around the world for being part of the International Moon Day and for all the events that they are organizing. The Moon Village Association is an NGO which is registered in Vienna in 2017 and is acting as a unique platform to bring together space agency, government, industry representative, academia, international organization, and the public to discuss and conduct peaceful lunar exploration and utilization. It is a unique organization, and we had developing several activities, which is ranging from technical to economic, as well as to culture. But many details can be seen on the MVA website. MVA is also a permanent observer at the United Nations COPUOS, and in that respect has an important function and has given strong, important contribution. And one of these contributions is the proposal to set up, create the International Moon Day, and this has been approved in a very fast way from the General Assembly in 2021. So detail of the International Moon Day and the theme, as well as all other information related to the International Moon Day, will be delivered by the chairman of the International Moon Day, Dr. Nasser Al-Saud. So I just want to take this opportunity to thank all the participants of this event. It's important that once a year, at least, people from all the world take the time to discuss within themselves, with the public, what does it mean going forward to the moon, and what does it mean for humanity to harvest resources.
Okay, then we go to the next welcome remark. And do you hear me now?
Yeah, we can hear you, but not the video.
Okay, I will start the video.
Chair of the International Moon Day. It is with great pleasure to welcome you to our third celebration of the IMD. But first, allow me to give you a brief about the origins of the International Moon Day. On 9 December 2021, the United Nations General Assembly declared the all member nations to celebrate the International Moon Day every year on 20th July to commemorate humanity's first landing on the moon more than 50 years ago. Our inaugural celebration was held in 2022 at the Drake State Community and Technical College in Huntsville, Alabama, home of the Saturn V rocket, which propelled the Apollo program to the moon. Our second celebration was in 2023 at the Science Museum in Gwacheon, Korea. This year, and for the first time, our third celebration of IMD is held in two countries simultaneously, at the Harbin Institute of Technology in Harbin, China, and in Rostock, Germany, coinciding on the same day, featuring roundtable discussions by panels of world-renowned space experts from industry, government, and academia, which should make for very intriguing discussions. And you're welcome to stream it online from our official website at www.internationalmoonday.org. The theme for this year is illuminating the shadows. Illuminating the shadows can refer to a number of things: the life-giving water that is thought to sit in the permanently shadowed craters, the engineering and research that is necessary to get us back to the moon, and of course, public awareness. Revealing mysteries surrounding the exploration of the lunar surface prior to establishing a permanent settlement for scientists to work and live on the moon in the next decade. The IMD is a very special occasion to raise awareness and interest among the public at large about ongoing international efforts towards returning to the moon in a sustainable fashion, not only to explore and harvest the moon for its rich abundance of rare metals, but also as a springing point to other planets and the stars. Additionally, this year we have around 40 global events such as yours, held in 40 countries around the globe. In conclusion, I wish you all a very successful global IMD event wherever you may be, and God bless.
Okay, thank you. Just to let you know, we'll send the attendance list after the photo session. All right, everyone, it's time to give a big welcome to our speakers. Let's greet Farah, Pelin, and Lakita. How's everyone doing today?
Amazing. Thank you so much for asking, Shaida. It's very nice to see you.
Yes, I'm here. Amazing. It's nice to meet you all.
Thank you. Yes, I'm quite well as well. And thank you, Shaida, for moderating the session today, and Farah for inviting me to be here. It's lovely to see you guys again.
It's my pleasure. It's my pleasure, everyone.
Yeah, it's very nice to see you. So the first question for all three of you, it's what is Legalese and why it's important? We will start with Lakita, followed by Pelin and Farah.
Yes, thank you. So legalese refers to the language, the formal and technical language, so words and phrases that are used by professionals in this field, so most notably lawyers, but other professionals within the legal field. And it's used in this field to communicate, whether it's through verbal communication or written communication. And when we discuss its importance, I think there's a general importance when we talk about legalese. So as individuals within our societies, it's important to understand what rights and obligations are ours. So for example, within your country creates laws that determine what you can and cannot do. And then on the level of governments, when they create treaties or they have relations, that can indirectly affect you as an individual in terms of where you can go and how freely, what restrictions there may be in that regard. And I think for our purposes today, what's really important about understanding legalese is the fact that we're entering this relatively new field and we need to collaborate in order to move forward. And for us to collaborate, we need to have a common understanding of the rules that guide us and how we're going to get there. And so that requires us understanding what the law says, what it means, what gaps may be there, and how we can chart that way forward. Thank you.
To be honest, I definitely agree with you, Lakita. What you said, it's very important. But to be honest, if I would like to give like an individual experience that I received 2 years ago in the university, in Northumbria University, when I was doing my master's degree in the space law. I had a chance to meet some people from the professional way for 20 years in the law degree. They received their degree on 20 years ago, and they were in a professional area of the law and doing like a very, very hard court cases. And we had a chance to have the same assignment together, and we received our feedback, but it was so disappointing to see that they received bad marks from after even 20 years of their like a full-time working experience, because the problem is they were saying that the feedback was saying that they are not clear enough to explain what they are trying to say. 20 years ago, they were saying to them that write your assignment, then let your mother to read your assignment. If they don't understand, it means you done something good. But to be honest, in this time is not the case. This is the like, if you don't understand, that is the like you wrote something that nobody can understand and you have to translate it. It's like you already learn one language to translate something and you have to learn another language for in the English too. I don't know. It's so hard and complicated, but at the same time, I understand the fundamental importance of the legalese, and I can say that like we need some terms, and some of the terms has to be clear in the legalese. But yeah, my side is this. Yeah, thank you.
Amazing, Lakita and Belin. Well, for me, legalese is a secret code from jurists or lawyers. No, I'm just kidding. Well, it means all phrases, words, and elements mentioned in a legal document, such as acts, decisions, or today's topic is an international agreement. And I'm sorry for the noise. Legalese is from theories, principles, prior legal products, and our daily vocabularies. And of course, legalese is important for legal practitioners to communicate with each other, help our clients, and make a provision or a legal statement clearer and more precise when indicating a legal action, subject, scope, definition, legal event, and etc. That's all from me, and back to Seda.
Thank you. Farah, can you explain how this class will increase public awareness of space activities, particularly about the moon?
These online settings help us to reach the public broadly and globally in knowledge transfer and exchange by understanding the legalese in the Moon Agreement that introduces the public to global space actors' orientation and scopes, and as well as enhances curiosity about space activities and its laws.
Thank you, excellent. Okay, moving on to today's main session, introductory class of the legalese in the 1979 Moon Agreement. Articles 1 to 7 will be delivered by Lakita for 10 minutes. I will share for you, and the floor is yours.
Okay, while she's doing that, good morning, good afternoon, good evening, everyone. I'm really happy to be here. I am Lakita George, and as Shaida said, I will be focusing on Articles 1 to 7 of the Moon Agreement. Okay. Ready when you are, Shaida.
And I forgot to share.
That's okay.
Okay, now you can see, yeah? You can see, I think. Okay.
Yes. Okay.
Yeah,
So
I will.
just Mhm.
Yeah.
Okay, fantastic. So I will begin. So starting with a bit of background, the agreement governing activities of states on the moon and other celestial bodies was adopted on the 5th of December, 1979, and entered into force on the 11th of July, 1984. There are now 17 adherents because, as of January of this year, Saudi Arabia officially withdrew from the moon agreement. Amongst these 17 states parties, none of them are major spacefaring nations. The Moon Agreement is the last of the 5 treaties forming the international legal framework and serves to supplement the Outer Space Treaty of 1967. If we turn our attention to the preamble, we see a few things. Firstly, it acknowledges the strides made up to that point in exploration and the benefits that could be derived from exploiting the moon's natural resources. It also recalls the principles of international cooperation and the goals of preventing international conflict as set out in the Outer Space Treaty. Finally, it acknowledges the need to define and develop the provisions of previous international instruments in relation to the moon and other celestial bodies. Next slide, please. So turning to Article 1, this article sets the parameters of the application of the Moon Agreement, and it provides that the Moon Agreement will cover activities on the moon, other celestial bodies within the solar system, insofar as there are no other specific norms that have entered into force to govern these, and orbits around and trajectories to and around the moon. It does not cover extraterrestrial material that reaches the Earth's surface by natural means. One point that authors have underscored is the absence of a definition of celestial bodies. From an astronomical perspective, celestial bodies can take different forms. And so from a legal perspective, we need to determine whether we are going to be discussing all forms of celestial bodies or whether we're going to focus on a few. In that regard, some authors have suggested a distinction based on the whether human exploration is feasible or whether there is a human value. However we choose to go forward, a clear definition is necessary to clarify the scope of the Moon Agreement. Next slide, please. Turning to Article 2, this article provides that all activities on the moon are to be carried out in accordance with the UN Charter, more on that later, and the Declaration, in the interests of promoting international cooperation and maintaining international peace, which echoes the preamble and Article 3 of the Outer Space Treaty, as well as the preamble and Article 1 of the UN Charter, and with due regard to the corresponding interests of states parties. And on this point, I'd like to make 2 subpoints. Firstly, concrete guidance is needed concerning the definition of due regard. Because it's not been clearly defined, it is open to interpretation, and so the diverse perspectives of different states. Once we get clarity on it, we can create a harmonized interpretation that can guide states parties moving forward. The second point I'd like to raise concerns the common heritage issue, which will be discussed later by my colleague. But I'd just like to raise this one question that some authors have pointed out. And this is that if the moon is meant to be the common heritage of all mankind, yet Article 2 limits due regard to the interests of the 17 other states parties, can we truly say that it is the common heritage of all mankind? Next slide, please. Article 3 discusses demilitarization and de-weaponization, and it explicitly provides that the moon is to be used exclusively for peaceful purposes, which echoes the Outer Space Treaty again. It then provides examples, as you can see on the screen, of activities that are prohibited and those that are allowed. One interesting point in Article 3 concerns the prohibition against the use of force. If we recall our earlier discussion on Article 2, that provided that all activities are to be carried out in accordance with the UN Charter. And if we look at the UN Charter, in Articles 42 and 51, they both provide for the use of force. Article 51 describes it as an inherent right of self-defense in the event of an armed attack against a UN member state. And Article 42 provides that the Security Council can authorize the use of force to remove a breach of the peace. Therefore, it would appear that the use of force may be permitted following the UN Charter, even though it is prohibited under Article 3. Next slide, please. Turning to Article 4, this article provides that the exploration and use of the moon shall be the province of all mankind, echoing Article 1 of the Outer Space Treaty. It also recalls the principle of international cooperation and added that this can take place on multilateral and bilateral bases or through international intergovernmental organizations. Here again, we need a definition of the term province of all mankind. Some authors have suggested a distinction between province of all mankind and common heritage of all mankind, suggesting that the province of all mankind focuses on activities. Dr. Frans van der Dam has suggested that the province of all mankind is a form of terra communis, and this means that we're operating or we're departing from the freedom to explore and use, with an additional obligation to not cause significant harm. There is some support for this in Article 4 itself, which says that these activities, the exploration and use of the moon, shall be carried out for the benefit of all countries, and that there should be due regard to future and present generations. But again, clarity is needed to clearly state what this concept is intended to mean. Next slide, please. So Article 5 addresses notification obligations to the SG of the UN, the public, the international scientific community, and it details the type of information that needs to be provided, when that information needs to be provided, and in what contexts. This serves to foster international cooperation and transparency amongst states parties, as well as building that mutual trust and facilitating the benefit sharing that was referenced in Articles 2 and 4 above. So you can go to not the next slide, the slide after that, which would be Article 6. Thank you. Article 7 provides for the freedom of scientific investigation. States parties enjoy a number of rights regarding this freedom of scientific investigation. For example, the right to collect and remove samples of minerals and substances from the moon, the right to retain these samples that they've collected and use them for scientific purposes, etc. States parties are also encouraged to share the scientific personnel and samples in an effort to foster that international cooperation that we've seen throughout the Moon Agreement so far. One challenge that has been pointed out by some authors is that scientific investigation and commercial ventures are inextricably linked. And often, commercial ventures are born out of scientific investigations. So the question that remains is, when does an activity become a commercial venture? Next slide, please. Finally, Article 7 calls for environmental protection. And states parties are called to take a number of steps. For example, measures to prevent the disruption of the existing balance of the environment on the moon as well as on Earth. They also are called to inform the SG of the UN of the measures that they've adopted and notify the SG in advance of placements by them of radioactive materials on the moon, as well as the purposes of these placements. They are also called to report to other states parties and the SG concerning areas of special scientific interest on the moon, so that consideration can be given to designating these areas international scientific preserves, and so that agreement can be arrived at concerning special protective arrangements. And this brings me to the end of my presentation. So thank you very much for your time, and on to the next speaker.
Thank you very much, Lakita. It was very comprehensive. And now we have Farah for presenting Articles 8 to 14. Floor is yours.
All right, thank you. Just give me a second.
I can share for you too if you want.
I know it's all right.
Ah.
Can you see it, everyone?
Yeah, it's okay.
Okay, amazing. All right, hello again, everyone. Oh, wait, oh, all right. Okay. Hello again, everyone. As you can see in my display name, I'm Farah from Farah Law School, and I'm sharing an introduction to the Legalese in Article 8 to 14 in the 1979 Moon Agreement. And because it's an introduction, it should be not that complicated, hopefully. All right, so everyone, to make my delivery faster and easier to understand, these are a short mention list of international space law instruments I use today. You can screenshot it if you want to know the full names of these instruments. So for example, if I refer to this agreement, I will call it as Moon Agreement. Okay, next. All right, so this provision, Article 8, discusses astronaut and space object activities on the moon. The activities refer to exploration and use of the moon anywhere, including land, launch, place, and move their personal and space objects. Then you can see these are the space objects, space vehicles, equipment, facilities, stations, and installations. Since this and the next provision have more common or daily vocabulary inside, so I will highlight only some phrases that I think it's essential. So here, state parties. State parties means a state that consents to be bound to the agreement through ratification and accessions. Both are expressions to be bound, following with states' internal processes and depository to the Secretary General of the United Nations. But ratification is for states that participate while negotiating in the agreement, and accession is for states that want to be bound after the agreement enters into force. And about signatory states that are not included as state parties but as participants. It's based on Article 12, Paragraph 1, Clause A of the Vienna Convention, states that signatory states, a signature can be consent to be bound if the treaty provides that signature shall have that effect. Even a signature shows acceptance or approval. In this case, the Moon Agreement excludes signatory states, as in Article 19, paragraphs 2 to 4 mention that the agreement shall enter into force after the 30th day of the date of deposit of ratification or accession instruments. And state parties in the Moon Agreement includes astronauts, international, intergovernmental, or non-governmental organizations, national organizations, or non-governmental entities, or any natural person as delivered in Article 10, Paragraph 1, Article 11, Paragraph 3, Article 14, Paragraph 1, and related treaties such as Liability Convention, especially in Article 14, Paragraph 2. Then Article 9. Article 9 contains stations establishment and installation. That area in this provision, as you can see, we shall not establish or install a station without exploration and use reasons, such as claiming a jurisdiction. So the scope is under the needs of the station. Another I highlight here is such a manner. I found some local jurists questioning this. It is the same way with mean or how we do the installation of a station. And Article 1 Outer Space Treaty, as you can see, this paragraph 2 mentions about Article 1 Outer Space Treaty. It covers about non-discrimination, equality, and accordance with international law. This is one example that reading just one provision or just one entire agreement is not enough. If you want to understand a provision, you might need to study other related treaties. And Article 10, I underline this so we can know why state parties shall guarantee astronaut safety, including those who are not our nationalities. Based on Article 5 Outer Space Treaty, the astronaut is an envoy of humans in outer space or a representative of human in outer space. And Article 10 in this agreement is a reaffirmation of the rescue agreement. And after that, you can see this modal verb, shall. Shall in our daily conversation refers to suggestion. However, this agreement stands for requirements and duties. In international space law, the word must only can be found in soft law, like declaration or principle. Another close function with shall, it should. And should is for duties or functions attached to the position, like in this agreement you can find in the Secretary General function, but not in this article. All right, so Article 11. Article 11 is very interesting to me. As you can see, Article 11 covers the common habits of mankind and the international regime, which makes this agreement the only hard law instrument of space law that includes commercial use. The definition of the common habits of mankind itself is varied and still debatable, honestly. But I will say it as a combination of the province of all mankind, benefit and interest of all countries to present and future generations. So the first one, province of all mankind, talks about location, benefits, and interest of all countries, talks about needs. This based on Article 4, Paragraph 1, Moon Agreement, and Article 1, Paragraph 1 of the Outer Space Treaty. Then exploration, you can see here in Paragraph 4. Exploration is for research activities or purposes, and use is for general activities. And the exploitation is for exclusive utilization of the moon's natural resources for economic and commercial purposes. Well, how do I know? Exploration and use are connected to economic or scientific development in Article 1, Paragraph 1, Outer Space Treaty, and exploitation you can find the repetition in consideration of this agreement in addition to this provision. Still in Article 11, moving on, the international regime in this provision, according to its purposes, encompasses agreement, practice, and institution or body. So this is also relevant to Miller's theory in Theories of International Regimes book. And then we can talk about the second legalist, and means that all elements must be met. So in this case, we can say state parties follow Article 11, Paragraph 6, if they inform their discovery to the Secretary General, the public, and the international scientific community. However, if one of them is not informed, the state parties do not fulfill this provision. Then let's talk about or. Or is for alternatives or options between elements. So if a state party gives special consideration who contribute directly to the exploration only, that state party already fulfilled this provision. All right, so Article 12. Article 12 stipulates on jurisdiction and control of personnel and space object use, as well as assistance in emergency conditions. Well, everything looks good, but let's talk about jurisdictions. Jurisdiction might have diverse meanings in legalese, such as the power of a court or authority to decide a legal case or territory. Well, in this agreement, jurisdiction stands for activities of personal and space objects, as you can find here. We cannot say territory because the moon is not subject of national appropriation. The only subject to national appropriation is in this provision is our astronaut and state parties' properties. This provision addresses the unintended landing of a space object that does not belong to a state party who notices this incident, and it can belong to another state party or even a non-state party. I just want to reaffirm here that this provision is only applicable to the moon activities or incidents. So if there is a space vehicle crash landing on the surface of Earth, you can go to the previous treaties, not this agreement, like rescue agreement, liability convention, and other space treaties, especially in Article 5. Next, Article 14 talks about international responsibility and liability. International responsibility indicates preventive and repressive actions that do not require compensation, such as in this paragraph that state parties shall assure national activities are carried out in conformity. After that, liability. Liability is a repressive action of a damage followed by compensation for the restoration of a condition. You can find these differences in Articles 6 and 7 World Space Treaty and Principles 7 and 8 of the Nuclear Use Principles. And for the liability followed by compensation, you can learn in Article 11 liability convention. And about regarding damage, as it says that it is related to the liability convention, damage in Article 1, Clause A of the convention means loss of life, personal injury, or other impairment of health or loss of damage to property of states or of persons, natural or juridical, or property of international intergovernmental organizations. So it's anything impact that caused damage to your property or injury to a person. We can call it as you can sue a state party for liability, for their liability. All right, just a little bit of closing statement. Legalese in your country and mine, or international scope, or a distinct law field, or a different legal product might have different meanings and interpretation, even it seems the same word or has similar nomenclature. So make sure you explore related provisions within or outside of a legal document before you conclude the meaning. And about these references, a little bit information also. I prefer to use treaties from the United Nations Treaties Collections version because you can find detailed and updated information, including who the state parties are with the date of their consent to be bound in one sources. Thank you, and back to Shada.
Thank you very much, Farah. It was very insightful. And now the Articles 15 to 21 will be presented by Pelin.
Hello, thank you so much. Let me share mine too. Let's go. It was, by the way, thank you so much for Farah and Lakita for the presentations. They were amazing. I hope you can see it clearly. I'm not going to challenge my articles that Lakut and Farah did. I'm going to share something that what I understood from my articles. And to start with, we will start the Article 15, transparency, and just 1 second. Let's remove this one here. Okay, the transparency and cooperation. Transparency and cooperations are the bedrock of Article 15. This article ensures that all the activities on the moon align with the agreement's provisions. It grants each state party the right to inspect and ensure the compatibility of the activities conducted by other state parties. This is crucial for maintaining safety and mutual trust, to be honest. State parties must give reasonable advance notice of visits to lunar facilities and allow open access for inspections. This ensures that there is no interference with normal operations and maximum safety precautions are taken. Moreover, Article 15 establishes mechanism for resolving disputes through the consultations, emphasizing diplomacy and mutual respect. If issues arise, state parties can seek assistance from the United Secretary General, ensuring transparency and accountability in resolving conflicts. If we move to Article 16, is the extension to international organizations. This is a significant step as it reflects to the collaborative nature of modern space exploration. And these organizations must be declared their acceptance of the agreements, rights, and obligations, provided a majority of their member states are also parties to the agreement. This extension promotes global cooperation and collective responsibility in lunar activities. It ensures that international organizations engage in the space exploration adhere to the same principle and obligations as individual states, fostering a unified approach to the peaceful use of outer space. Okay, and Article 17, amendment of the adaptability. Flexibility and adaptability are the heart of the Article 17. This article allows state parties to propose amendment to Moon Agreement. This amendment must be accepted by a majority of state parties to become effective. And this provision ensures that the agreement remains relevant and responsive to technological advancement and evolve.
Jangan di laptop toh. Turun. Turun.
It's somebody needs to mute their thingy, I think. Okay. And where I was, okay. The ability to amend the agreement is vital for the maintaining its relevance over time as our capabilities in space exploration evolve. So to master legal frameworks to govern these activities as well. And Article 17 ensures that the Moon Agreement can adopt to new challenges and opportunities, promoting sustainable and responsible exploration. Article 18, review and evaluation. Article 18 mandates periodic reviews of the Moon Agreement's implementation. 10 years after the agreement enters to the force, a review is conducted to assess its application and effectiveness. This process allows state parties to evaluate achievements, identify challenges, and propose improvements. Periodic reviews are essential for ensuring the agreement's long-term success. They provide opportunities to reflect on past experiences, address emerging issues, and incorporate new technological developments. However, I would like to state that this review and evaluation, Article 18, it's never happened after even so many decades has passed, and there was so many enforcements as well, but they never had a chance to do the reviewing session. Article 19. Signature, ratification, and entry into force. Article 19 outlines the procedural aspects of the Moon Agreement, emphasizing inclusivity and universal participation. The agreement was open for signature at the United Nations headquarters in New York and is open for accession at any instrument for ratification or accessions are deposited with the United Secretary-General. The agreement enters into force on the 13th day of following the deposit of the fifth instrument of ratification for each state depositing its instrument after the agreement's entry into force. It becomes effective 30 days following the date of deposit. This structure approach to encourage widespread participation and adherence to the principle governing the peaceful use of outer space. I would like to again add something on this article because it was stating that it's the fifth person, the instrument has to be ratified, then they can put in force all the Moon Agreement onto the members. However, indeed, the Moon Agreement adopted by the United Nations General Assembly in 1979, and it was open for the signature immediately after adoption. However, it took 5 years to find the last fifth country to ratify the agreement. And thanks, it was the Austria who ratified the Moon Agreement and make it possible to put in force and the agreement. Article 20, third, withdrawal and sovereignty, is after more or less is sensitive issue of the withdrawal from the Moon Agreement is acknowledged the sovereign rights of state parties while emphasizing the importance of continuous and stable in international cooperation. A state party may withdraw from the agreement 1 year after its entry into force by providing written notification to the UN Secretary-General. The withdrawal takes effect 1 year after the notifications received. This provision ensures that the withdrawal decisions are made with the careful consideration of broader international obligations and responsibilities. It balances the rights of individual states with the need for ongoing collaboration and stability in space activities. Like Lakota quoted before, Saudi Arabia was the first country has been withdrawn from the space treaty. Any related space treaty, and it was the first member who withdrew from the Moon Agreement. They, in 2023 January, they notified the United Nations Secretary-General in New York about their withdrawal, and in 2024 officially they've been removed from the agreement. And the last one, Article 21, depository and authentic text. Finally, Article 21 designates the United Nations Secretary-General as a depository of the Moon Agreement. The Secretary-General ensures that the authenticity and accessibility of the agreements takes in multiple languages like Arabic, Chinese, and English, French, Russian, and Spanish. This provision underscores our commitments to transparency and accountability in the governance of lunar activities. It ensures that all state parties have access to the authentic text of the agreement, facilitating clear communication and understanding of the principle guiding our action in space. To conclude my articles, Article 15 to 21 of the Moon Agreement form a comprehensive framework for peaceful and sustainable exploration of the Moon and other celestial bodies. As we navigate the challenges and opportunities of the space age, let us uphold these principles with diligence and foresight. Together, we can ensure that our endeavors in space serves interest of all humankind, both present and future, by fostering cooperation, transparency, adaptability, and we pave the way to a future where the space exploration continuously peace, progress, and prosperity for all. Thank you so much for your attention, commitment to the peaceful exploration and use of outer space. Thank you, future space leaders. And I'm handing over to the Shaida. Thank you.
Thank you, Pauline. That was very interesting. For the closing statement, we will hear a call to action from the speakers, starting with Pauline, then Lakita, and finally Farah. You are muted, Nashida.
Yes, amazing. Because I lost everything. My laptop is getting super hot when I do the video. Sorry. The technology is very important, but you need to up to date. Otherwise, it's not that good. Is it possible to have the question again, Shaida?
It's time to hear a call to action from you.
Yes, I believe that we definitely keep going with the Moon Agreement. However, I do believe that it needs to be changed a lot. We can keep some fundamentals. However, we need definitely include more countries in there, and we must think about the commercial way as well. And we need to get access to all commercialized things and to get private companies. Like we need to get the private companies more than the governments, to be honest, at the moment, and to push them to obey the rules and for the all humankinds, and bring the peace for the space. Thank you.
Okay, we can continue with Lakita.
Thank you, Shaida. And I also agree with you, Nashide. I think we do need all hands on deck. And so my call to action is quite similar to what you're saying here. We definitely need to have another look at the Moon Agreement and see how it fits into our current society and where we're heading. And to do that, we do need to get different stakeholders involved. And so I would just urge everyone, even though today we're discussing the legal aspects, as Nashide pointed out, there are other aspects that we need to consider. We need to consider those commercial incentives and find a way to compromise so that we can move forward to create that sustainable future that we're all, calling for. So yeah, thank you.
Yeah, we can continue by Farah.
All right, thank you. So if you guys think space activities are such a myth, you have to start exploring your surroundings, simply like Wi-Fi in your home or office, where it comes from. And you can find some news about when space debris could hit hit the Earth's surface and cause damage in certain locations of China and India. So it's time for all of us to be aware of space activities urgency and ensure stakeholders follows our space regulation, not only in international but also national. Thank you.
Thank you, everyone. Now it's the time for Q&A session. We're open to 4 questions. You can raise your hand and then turn your camera, or you can type in the chat box. And now I think you have a question from Melissa. I think this question is for Nashide. She asked about why Saudi Arabia withdrawal from Moon Agreement.
This gonna be very it's gonna be my opinion. I think the Saudi Arabia had in 2012 they access to the Moon Agreement. I think in that time they weren't that engaging in the Saudi in the space, and they were thinking is the best idea to get on the agreement and be on the table and has a say. But for decades, they realized that maybe it's better they realized that the US or Russia or China hasn't signed a contract or the agreement, and they were following. And I think it was last year when they signed the Artemis Court as well. I think because of that, they changed, because the Artemis Court and the Moon Agreement has many significant differences. And I think just because of that, or maybe they want to do their internal space law, like Japanese and Luxembourg, how they did. Maybe they want to create their own law, maybe. Yeah, I hope I answered. Thank you.
I think Reza raised his hand. You can start, Reza.
Okay. Thank you very much for the opportunity. My name is Reza. I'm from Indonesia Defense University. I study defense diplomacy there. I have 2 questions. My first question that are there any identified loophole or ambiguities in the Moon Agreement that could be exploited for a military or defense purpose? And how might this be addressed in future international agreements? And my last questions, how does the Moon Agreement address the issue of self-defense for nations with space operations? We know that several First Nations have own space force. For example, US Space Force, China Space Force, Russia Space Force, and so on and so forth. So how how the loophole and what limitation are imposed on defensive measures? Thank you very much.
What do you think is the question is related to
For
which
to be honest, if I start, maybe like I can do the combination, like an answer. I believe that in my articles, I saw that the cooperation is the most important thing in the Moon Agreement, and how Sarah stated that when the astronauts, if something happens, we have a rescue agreement as well. I think with this agreement, if in the future if something happens, everyone has to come together for that one member to protect and defend for themselves. I think this is like a collaboration, and I know that there is not many countries in the Moon Agreement that has any space. Like there is actually very few of them has a space-related actions is happening in their countries. However, I believe that in the future, if something happens and if the more strong countries who has more involved in the space and in space technologies, they will start to take the lead to protect the other members. And this is gonna be like a combination, will be like they will protect each other with the one of the leaders, and then maybe they will be another give and takes thingy. I think this can happen in the future. Yeah, my understanding. This is on.
Yeah, oh, sorry. Go ahead, Shane.
No, it's okay. You can say.
Yeah, so I was just going to agree with you on that, but I wanted a bit of clarity on the first question. I was trying to make a note of it. I got that, are there any ambiguities in the Moon Agreement with regard to defense? Was that the question, Reza? And how can it be used? If you can just repeat that first question, I'd be really grateful, and maybe I can better respond. Okay, thank you. So with regard to your first question, if we go back to, let me just pull up my presentation 1 second. I believe it is Article 3. We see here that it specifically prohibits military maneuvers that aren't for scientific purposes. Now, of course, we have to recognize that not only the moon, but outer space, as well as the technology that we're using, including satellites, for example, have that dual use nature. So the law cannot envisage every configuration of an attempt to abuse a system that has a dual use nature. So as Nishide would have mentioned before, we've got these other principles, so that principle of international cooperation. So it comes down, yes, we've got this Article 3 that specifically says the moon has to be used for peaceful purposes. But if a country intends to do something nefarious, a law isn't necessarily going to stop them. What works is that we come together as a global community with a common understanding. So if we've created this law that says we're not going to have military maneuvers, we have to hold ourselves accountable as states parties and hold each other accountable and set that tone. because of course, as we recognize, the Moon Agreement hasn't received a lot of acceptance. So there are issues therein that can make it difficult to prevent that if a state isn't party to the agreement. And also, as Farah had mentioned before, there are other treaties that treat with this as well. So what isn't in one agreement, we may find through other agreements that can deal with those things. And so it's why it comes down to us as a global community understanding not just one simple agreement, even though today's discussion is about the Moon Agreement, but understanding that there are other agreements that feed into this and other actions that feed into this. So we've got the legal perspective, but we also have to have political will. So it requires that combination, which is why the international cooperation is so important. I'm going to just think about your other question, but my battery is dying, so please excuse me one moment. I'm still having a quick think about your second question, Reza. So if anyone else wants to add anything in the interim, please go ahead.
Yes, I have. Can I add something, everyone? All right, so to answer your first question, Reza, actually self-defense is prohibited. For short, it's prohibited because if you want to look back to the Article 4 of Moon Agreement, it's absolutely prohibited as long as it is not for scientific or peaceful purposes, because self-defense is absolutely not for peaceful purposes, isn't it? And then about the your third question, I think ambiguities. All right, ambiguities. The second question, sorry, your second questions, ambiguities. As I told earlier, that ambiguities in the Moon Agreement is actually talked about in common heritage of mankind, because sometimes we can translate it as res communis humanitatis or res communis omnium, but I want to deliberate comprehensively in this session because it's for introduction. So those ambiguities can lead us to like translate Moon Agreement can be for military purposes beyond peaceful and research purposes. But if we want to be clear, if we want to be like direct to the Article 4, it's absolutely prohibited. About limited number of signatories, your third question. As I said, that signatory party is just a consent to be bound, but not bound to the agreement. So it is something like, yes, I'm agree with this. I think this agreement is cool. So yeah, we can talk about it during the discussion, but it doesn't mean that I will force this agreement in my country. So this is the difference between signatory parties and state parties in the Moon Agreement. So limited number of signatories, of course, affect to the cooperation and actions of the effectiveness in preventing militarization of the moon. Because if there is a country who do not part of the treaty, I mean, as a state party, of course, they can think they can make activities that they think it's not part of their responsibility. I hope that answer your question.
Thank you everyone for your questions and answers. For conclusion for today's event, legal English or I was muted. And thank you for answers and your questions. For a conclusion for today's session, Legalese plays a significant role for practitioners in comprehending international instruments such as treaties, agreements, decisions, and etc. It is not limited to human activities on Earth, but also in outer space. including lunar exploration and exploitation. Understanding this significant impact of Legalese helps students and professionals take concrete actions now and prepare for the future. That's it. Now let's capture a memorable picture. You can turn on your camera and we can take some screenshots. Okay, I give some seconds to you if you need, and then I screenshot. Okay. Farah, shall I change the layout for cameras? How can I do it?
I'm sorry, Syria, come again.
Can we change the layout for cameras?
Oh, it's already in members. I mean all participants slides. I can screenshot it. It's all right.
You can give a screenshot. It's okay. Thank you.
All right. 1, 2, 3. Smile, everyone. It's slide 1. Another slide. All right, slides 2. Amazing. It's done.
Thank you. I hope this session provides valuable insights into legalese and space law. Here's the link to the attendance list. I'm sharing in the chat box. Let me paste it. Now I think you have access, yeah? Yeah, I think that you have access and you can fill it, and I've sent it the chat box. See you in the next session. Thank you for attending, and thank you Lakita, Nashida, and Farah, and thank you for those who ask questions and answers. Thank you. Goodbye.
Thank you, everyone.
Thank you.
Bye. Have a great night, evening, and
Thank you, everybody. Bye.
Bye. Good night.